Shows that we are on the record.
Ask them if they can hear you.
Can anybody hear me?
Yeah, I guess they hear you. Maybe there's another one to turn on for main jail. There we go.
Good
Can you hear me
morning.
now?
Good morning,
Good
yes.
morning, Judge.
You can hear me okay, and I can hear you.
Perfect.
Okay, great. We're here this morning for magistrate's first appearance hearings. I'm going to call the names in the order that I have them unless anybody needs me to go out of order. I do have a couple of attorneys here. I can try to call those cases if you don't mind that.
Not at all.
My understanding-
The justices are requesting that one gentleman be called out of turn.
That's
Judge.
what I understood. Which case is that?
On page 8, the gentleman's name is Mr. Glenn Ebersbach.
Okay, and where is he?
He's in the
He's
main
right here at
jail.
main, Judge, approaching.
Okay.
Come on up, sir. You can hold on to here.
Okay, Mr. Ebersbach is here this morning charged with possession of MDMA, possession of a controlled substance without a prescription, and possession of drug paraphernalia. I do find probable cause, and the bond has been set, convenience bond in the amount of $1,000 on count 1 and $1,000 on count 2. Does anyone wish to be heard with regard to bond?
Yes, Judge. I spoke with Mr. Ebersbach. I did advise him as far as the standard bond in place. Mr. Ebersbach wanted me to request the court to consider releasing him on pretrial release. Before I go on any further, I'll see if the state has an objection.
And, yes, Your Honor, on its face, I don't have an objection to pretrial random testing, just to advise the court. I spoke to Mr. Romero this morning about the case. I asked if Mr. Ebersbach has a place to live, because the PC and booking show at large. Mr. Romero advised me that Mr. Ebersbach advised him he has a place to stay in Pompano, but he lives alone. I don't know what the address is.
Okay.
Judge, my understanding in speaking to Mr. Ebersbach, he has a place to reside. He lives in Pompano Beach, where he's been residing for about, I believe, a year and a couple months. From what he advised me, he's been there. That's where he's going to go upon his release. That's where he's going to go and reside, Judge. So
Okay.
that's all I can advise the court at this time.
You show priors?
He does have priors, Your Honor. Last year, possession of substituted cathinones, drug paraphernalia 2017, trespass 2016, battery 2015. Other than that, I just see panhandling.
In light of the allegations in the probable cause affidavit, I'm going to leave the bond where it is at this time. So it's a total of $2,000 is the bond.
Yes, Judge. Could you sign a phone order, please?
Sure, I'd be happy to.
Thank you, Judge.
Our Spanish interpreter is present, Judge.
Okay, do you have the phone orders, or?
I got him.
Okay. So I'm just gonna push this over to you as best I can, is that good? Is that okay?
Just toss it.
Okay. Do you need me to save these assessments for any reason? Okay, we have a Spanish interpreter here. Could you tell me which case that might be on?
It's going to be Mr. Vale, and he is on page 6 of the docket. Come on up, sir.
Okay, sir, if you would, raise your right hand.
Yes, Your Honor.
Do you swear to translate and interpret from English to Spanish and Spanish to English?
I do, Your Honor. Gabriel Sinisi, court-interpreter.
Thanь you very much for
You're
being
welcome,
here.
Your Honor. My pleasure.
Mr. Vale,
Señor Bail,
you're here this morning charged with driving under the influence of alcohol and a traffic infraction for failing to use due care.
Está aquí por un cargo de conducir bajo la influencia de alcohol o drogas y el segundo cargo de no haber usado el debido cuidado al conducir.
I do find probable cause as to that charge.
Sí determino que existe motivo fundado con respecto a ese cargo.
A bond has been set in the amount of $500. I'll hear from either side if you wish to be heard with regard to bond.
Una fianza ha sido fijada de $500 y abro la sala a escuchar de las partes si desean hablar de algo.
Judge, I did speak to earlier with Mr. Lender. What I'm going to be requesting is the court consider releasing Mr. Vale on outright ROR or in the alternative, if the court's not comfortable with outright ROR, on standard pretrial release.
Su señoría, yo hablé previamente con el señor y estaría peticionando si lo podrían soltar bajo palabra al señor Bail, o si no está cómodo el tribunal con eso, si lo pueden soltar directamente a libertad provisional.
Your Honor,
Now, he just turned basically 20 years old. He's been living in our community for the past 3 years, Judge, and he works as a handyman.
Su señoría recién acaba de cumplir 20 años, este señor ha vivido en nuestra comunidad 3 años y está trabajando como mantenimiento y reparación.
He lives locally here in the city of Hollywood with his father, where they're renting an apartment.
Vive aquí en Hollywood con su padre, en donde están alquilando un departamento.
Unfortunately, he has no phone numbers memorized, so he wasn't able to contact his family to let him know he was arrested. So right now, his family does not know where he's located.
Desafortunadamente, él no ha podido memorizar ninguno de los números de teléfono, o sea que no ha podido contactar a su familia para informarles que él ha sido arrestado.
What
More
says,
importantly, Judge,
oh, sorry.
understanding is this is his first contact being with the criminal justice system, and he has a valid driver's license from what he informed me.
De lo que entiendo, señor, este es el primer contacto que él ha tenido con el sistema penal y él me ha informado que sí tiene una licencia válida.
What says,
Now, I did, I'm sorry.
oh, go ahead. Did you have anything else? I didn't want to cut you off.
My understanding, Judge, I did speak to him. I did advise him that he'll get a future court date in the mail. He will be coming back to court, so I have no sort of inclination that he is a flight risk.
Does he live at the address in Hollywood on Fillmore Street?
Yes.
Vives in Fillmore? Yes, Judge.
Okay. What says the state?
Your Honor, I don't have an objection to pretrial since he has no history.
Su señoría, no tengo objeción a que sea liberado bajo libertad provisional, ya que no tiene antecedentes.
The breath alcohol reading is concerning.
Exactly, Your Honor, and
Lo que me preocupa, señoría, es el nivel de lectura de alcohol en el aliento. Exactamente, señoría.
that's why I would oppose an outright ROR.
Por eso estaría opuesto a directamente libertad bajo palabra.
And if the court were inclined to place him on pretrial, I would be requesting random testing, no alcohol or intoxicants.
Y si lo pusieran bajo libertad provisional, estaría peticionando al tribunal que le hagan hacer análisis al azar.
And additional release condition, no driving without a valid license.
Y la condición adicional de libertad sería no puede conducir sin licencia válida.
Pretrial, is that any input? Okay. I'm going to release him to pretrial release.
Lo voy a soltar a la libertad, a la agencia de libertad provisional.
I am going to require that he be subject to random testing.
Y voy a decretar que sea sometido a análisis al azar.
He's not to consume any alcohol
No puede consumir alcohol
or other intoxicants
o ningún otro tipo de intoxicante mientras que está libre bajo libertad provisional.
while he's on release. And I'm going to require that he call in 2 times per week.
Y voy a requerir que él llame 2 veces por semana.
Yes, Judge.
Could you, Mr. Vale, it's going to be your responsibility
Señor Bell, va a ser su responsabilidad,
to look for your court date in the mail and appear in court.
o sea que va a ser su responsabilidad esperar o buscar también activamente su fecha de audiencia y concurrir y aparecer para esa audiencia.
You understand?
¿Entiende?
¿Entiendes?
¿Crees que me va a dejar salir y voy a regresar otra vez en mi corte?
Sí.
They're going to let me go and then I'm going to come back for another hearing, yes.
Yes. Thank you, Judge.
Mr. Vale,
Señor Bail,
upon your release, within 24 hours, you're going to be required to report to the pretrial release office.
señor Bail, dentro del plazo de 24 horas de adquirir usted su libertad, está obligado a reportarse y registrarse con la oficina de la libertad provisional.
Can you let him know where that is, please?
Señor abogado, ¿le puede por favor decir dónde queda eso?
I did, Judge, and I just gave him in a map which illustrates where to go after he's released.
Okay, perfect. Thank you
Ya
very
lo
much.
hice y le di un mapa donde tiene que concurrir.
Yes. ROR with pretrial release. Okay, I'm gonna try to call a couple of these attorneys if we can to, do we need an interpreter for anybody else?
Not at Main, Judge.
Okay.
Oh, wait, somebody does have, requires Spanish interpreter.
Okay, I do have an attorney here who said that he's here on behalf of someone who needs an interpreter. The name of the defendant is, what's the name of the defendant?
¿Qué es tu nombre? Tu nombre. Zacarías Reyes. Ahí está tu abogado. Page 9, Judge.
Okay, so if you would just put your name on the record for us.
For the record, Scott Sherman on behalf of Mr. Rosa Zacharias.
Para el acta del señor Sherman, para el señor Rosa Zacarías Reyes.
And Mr. Zachariah Reyes, can you see your attorney?
Y señor Zacarías Reyes, ¿usted puede ver a su abogado? ¿Lo puede ver?
Okay, you're here
Yes.
Mr. Zachariah Reyes is here this morning on one count of driving under the influence. It's alleged to be a third offense within 10 years. Second count of driving under the influence. Third count, operating without a valid license. Fourth count, felony driving under the influence. And fifth, driving while license suspended. It appears that he was arrested for driving under the influence, and at the time, there was an active capias for the felony DUI from Judge Bailey. Is that right?
Your Honor, if the interpreter may interpret.
Yes, please.
Thank you. Parece que el señor Zacarías Reyes está aquí esta mañana. El primer cargo es de conducir bajo la influencia. Tercer delito de conducir bajo la influencia dentro de un plazo de 10 años. El segundo cargo es conducir bajo la influencia con un nivel de alcoholímetro en el aliento .15 más o con una persona menor de edad de 18 años. El tercer cargo es operar sin licencia válida. El cuarto cargo es un delito mayor de conducir bajo la influencia. El quinto cargo es conducir con licencia suspendida. Parece que el arresto también, cuando fue hecho por el conducir bajo la influencia, él tenía una orden de arresto que había sido emitido por el juez Bailey.
Essentially,
As to those charges, I do find probable cause.
Con respecto a esos cargos, sí, también que existe motivo fundado.
and Your Honor, essentially that is correct. The only thing I would note,
Esencialmente, señoría, eso es correcto.
the capias wasn't directly issued by Judge Bailey. It was the clerk issued it upon the state filing and not in custody information.
Okay, so is it-
Esencialmente eso es correcto, pero la orden de arresto no fue emitida por el juez Bailey, sino por el secretario del tribunal al determinar que la fiscalía no lo tenía y que él no había sido arrestado.
okay, Mr. Sherman, I can hear from you.
Yes, Your Honor, my client has lived in Broward County for 15 years. He's an avid churchgoer. He works in construction, doing tile work. He literally lives paycheck to paycheck. I would ask the court to either consider pretrial release or the alternative to set a reasonable bond. Keep it in mind.
Counsel, your interpreter has to interpret what.
Thank you. Su señoría, mi cliente ha vivido aquí en Ciudad Florida 15 años. Él concurre ávidamente a la iglesia, trabaja en construcción, poniendo pisos, y él vive de un pago salarial a otro pago salarial. Le peticionaría al tribunal que lo libere bajo libertad provisional o que por lo menos imponga una fianza razonable.
Again, my client lives paycheck to paycheck. I was hoping that the court would either set a reasonable bond in this case or actually consider placing my client on pretrial release. He's also been charged with no valid driver's license, so if you could put him on pretrial release and require him to call in twice a week, I think that should cover the concerns of bond. He does.
Hang on, let the interpreter interpret.
Sorry.
Thank you. Como dije, su señoría, mi cliente vive de un pago salarial a otro pago salarial. Si le pediría que ponga una fianza razonable y que si no lo liberen a libertad provisional. Él no tiene una licencia válida y por lo tanto también pediría que, si usted fuese tan gentil, que él llamaría 2 veces por semana a la oficina de libertad provisional.
And with all due respect to the court, as the court knows, the 4th District Court of Appeals has regularly held that depending upon the financial circumstances of the accused, excessive bond is tantamount to no bond I think that putting the defendant on pretrial release should cover the court's concerns in this case.
Y también, como usted, con todo respeto a la sala, el cuarto distrito de apelaciones dice que la fianza debe ser impuesta de acuerdo a las circunstancias económicas y poner una fianza excesiva es como no poner fianza o no tener fianza. Entonces, por lo tanto, le pediría que lo ponga bajo libertad provisional y eso cubriría las preocupaciones del tribunal.
State.
Well, Your Honor, I would note that the fourth DCA has ruled that excessive bond is tantamount to no bond.
Yo, su señoría, yo también concurriría que decretó el cuarto distrito de apelaciones que excesiva fianza es como que si no tuviese fianza,
When all the factors that this Florida statute governs should be considered in setting a bond, not just merely the defendant's financial resources.
cuando yo arguiría que todos los factores tendrían que ser considerados de acuerdo a lo que establece el código y no solamente los factores de las circunstancias económicas.
In this particular instance, I believe the aggravating circumstances heavily outweigh any mitigating.
En esta circunstancia en particular, yo estimo que los factores agravantes pesan mucho más que los factores de aminoramiento.
I would argue that Mr. Zacharias Reyes poses a significant danger to all motorists in the community.
Yo también arguiría que el señor Zacarías Reyes impone un peligro a todos los conductores de la comunidad.
As the court is aware, Mr. Zacharias Reyes has 2 prior convictions for DUI.
Como ya conoce el tribunal, el señor Zacarías tiene 2 condenas previas de manejar bajo la influencia.
His most recent in 2013 also included a breath alcohol reading above a .15.
La más reciente, del 2013, también incluía una lectura de alcoholímetro en el aliento superior a .15.
And I would note as a result of that case, the DWS he's charged with on the not in custody
El cargo, y también notaría que el cargo de conducir con licencia suspendida por el cual no había sido detenido
is based on a suspension from that DUI.
es basado en una suspensión a raíz de ese otro cargo de conducir bajo la influencia.
His license was suspended or revoked. One moment, I just want to see.
Su
Lost the
licencia
screen
fue
for a
suspendida o
moment.
revocada.
Okay.
Déjeme ver.
His license was revoked for 7 years in 2014.
Su licencia fue revocada por 7 años en el 2014.
Additionally, as the court already mentioned, Mr. Zacharias Reyes was already wanted for a DUI involving a crash.
Adicionalmente, como ya conoce el tribunal, el señor Zacarías Reyes estaba buscado por un cargo de manejar bajo la influencia con accidente.
At the time, he was arrested for the new DUI that allegedly occurred on the 21st.
Cuando fue arrestado por el nuevo cargo de conducir bajo la influencia el día 21.
Your Honor, I'm going to be requesting a $10,000 bond on count 1,
Su señor va a estar peticionando una fianza de $10,000 para el primer cargo,
a $10,000 bond on count 4.
$10,000 para el cuarto cargo.
Should he post any bond the court deems appropriate, I'd ask that he be supervised by pretrial release.
Si llega a poder pagar las fianzas que imponga el tribunal que estime apropiadas, peticionaría que sea supervisado por libertad provisional
That he be fitted with a TAD monitor,
y que se le imponga un tag monitor
with additional release conditions, no alcohol or intoxicants, and no driving until further order of the court.
con condiciones adicionales de no beber ningún tipo de alcohol o intoxicantes y no conducir hasta que haya otra orden judicial a lo contrario.
Nothing further, Judge.
Nada más, su señoría.
The court does note that the driving record includes in 2016 another driving on a suspended license conviction, and in 2018, 2 convictions for operating without a valid driver's license. So
Sí,
based on the, oh, go ahead,
Sí
sorry.
toma nota el tribunal que en el 2016 también había cargos de conducir con licencia suspendida y en el 2018 2 cargos de conducir sin licencia válida.
Based on the facts alleged in the probable cause affidavit on the new arrest
Basado en los hechos alegados en el nuevo atestado policial
and the probable cause information with regard to the charge where the felony DUI was filed as a not in custody capias,
y basado en el nuevo cargo de que fue delito mayor sin haber sido detenido,
I'm going to set bond in the following amounts.
voy a fijar la fianza en los siguientes montos.
On count 1, driving under the influence, third offense within 10 years, I'm going to set bond in the amount of $10,000.
El primer cargo de conducir bajo la influencia, tercer delito dentro de 10 años, y voy a fijar la fianza en $10,000.
And count two, the bond is set at $1,000.
El segundo cargo, la fianza es fijada en $1,000.
Operating without a valid driver's license, bond is set in the amount of $500.
El tercer cargo de operar sin licencia válida, la fianza es fijada en $500.
And on the felony driving under the influence, bond is set in the amount of $10,000.
Y en el cuarto de conducir bajo la influencia del delito mayor, la fianza es fijada en $10,000.
As a condition of any of the financial bond release, if the defendant, as Mr. Zachariah Reyes does make that financial bond, he will be supervised by pretrial release.
Si llega a cumplir con el pago de la fianza, el señor Zacarías Reyes va a ser supervisado por la Oficina de Libertad Provisional.
He will be fitted with a TAD monitor,
Se le va a poner un monitor TAD
and he will not be permitted to consume any alcohol or other intoxicants.
y no se le permitirá conducir ningún tipo de alcohol o otro intoxicantes.
It goes without saying that Mr. Zachariah Reyes is not permitted to drive a motor vehicle. He doesn't have a valid driver's license.
Ni siquiera hay que mencionarlo, pero el señor Zacarías Reyes no tiene permiso para conducir, ya que no tiene una licencia válida.
Your Honor, may I be heard briefly?
Sure.
Puedo ser escuchado brevemente, su señoría.
I asked the court to reconsider the $10,000 bonds on counts 1 and the new count. My client does not have the financial ability to post that. The fact that if he had the financial ability to post that would not make him any less of a danger to the community or any less of a flight risk.
Le peticioné al tribunal que reconsiderara la fianza de $10,000, ya que mi cliente no tiene la habilidad financiera para pagarlo a esta fianza, y que lo pudiese pagar o no, eso no lo haría un peligro menos peligroso para la comunidad.
I appreciate your argument, counsel. I do think that the bond is the appropriate amount in light of
Aprecio
the
su alegato,
circumstances in this case.
abogado, pero sí pienso que la fianza es adecuada.
Yes, Your Honor, thank you.
Gracias, señoría, y gracias por su tiempo.
Yes, count five is going to stay at $100.
Y el quinto cargo va a quedar en $100, la fianza.
Looks like on page 7. For the next case, if we could call, looks like Mr. Plant is here. Do we have anyone else that appears to need an interpreter this morning?
Not at me, Judge.
Okay, thank you very much. I appreciate your help.
Yes, Judge, I'm Steve Plant. I'm here for Mr. Shate, Your Honor.
Okay,
Who has, if the court will appoint him. It's one case, Scott A. Coy, who's at Maine.
Scott Coy.
Good morning, Your Honor. He's in North Broward.
North Broward.
Yes, ma'am.
Sorry, sir, ma'am.
Good morning, ma'am.
Good morning.
Judge,
Is it Coy? Is that how you say it?
Coy, K-O-I, yes, ma'am.
Okay, Mr. Coy, there's an attorney present here this morning. I have appointed I'm going to appoint Mr. Shate to represent you. Mr. Plant is here in his stead, and you are charged with a municipal city ordinance violation. The allegation is an open container, and I do find probable cause for that charge. Yes, Mr. Plant.
Judge, I spoke with Mr. Coy this morning. He wants to resolve the case. The offer would be adjudicate time served.
Well, we don't have anybody here from the city?
No, but they don't come, Judge. But that's their offer. If not,
Well, I don't know anything about Mr. Coy, so I'd like to hear that before does anybody know?
I mean, if you're asking about priors, Your Honor, as a friend of the court,
Okay, could you do that as a friend of the court?
of course.
Okay.
Oh, thank you. As far as state priors, he had a 2017 failure to leave property, 2017 trespass, 2016 theft and resisting a merchant, 2012 2 counts of trespass, 08 delivery of cocaine, possession of cocaine, loading and prowling 08, possession of cocaine 07, another in 06, and another in 04 with possession of alprazolam and carrying concealed weapon.
He's arrested on the 21st.
Yes, Your
Is
Honor.
that right?
Yes, Your Honor.
If he wants to resolve the case today, I would adjudicate him guilty, sentence him to 5 days in the Broward County Jail. Credit for time served.
Sir, do you want to accept the 5 days?
Yes, sir.
We spoke earlier, right?
Okay, Mr. Coy, would you raise your right hand, sir? Do you swear or affirm to tell me the truth?
Yes, ma'am.
You can put your hand down. As I indicated, you're charged with a city municipal ordinance violation. I've appointed an attorney to represent you. Mr. Plant is here on your behalf. Are you satisfied with the advice and representation you have received from Mr. Plant and Mr. Shade?
Yeah, I just don't understand why it ain't time served, Your Honor.
Based on your priors.
The offer from the court is if you'd like to resolve the case today, I will adjudicate you guilty and sentence you to 5 days in the county jail. You obviously have a right to consult with your attorneys, and you also have the right to have a trial on this case if you'd like to.
No, I take the 5 days, Your Honor.
Okay, you under the influence of any alcohol or drugs here today?
No, ma'am.
Ever been treated for a mental illness?
Yes, ma'am.
Is the jail giving you some medication?
Yes, ma'am.
How do you feel today? Like you're making a good decision?
Yes, ma'am.
Any questions for me or for your attorney about what you're doing here before we go any further?
No, ma'am.
I can see that the probable cause affidavit does set forth a factual basis, and I will make a finding that there is a factual basis upon which I can accept a plea from Mr. Coy. Mr. Coy, how would you like to plead guilty or no contest?
Guilty, Your Honor.
I'll accept your plea of guilty. I'll find that you're alert, that you're intelligent, that you understand what you're doing, and I'm going to adjudicate you guilty, impose court costs in the amount of $293.
Excuse me, ma'am. Could you waive those costs on my disability? I can't afford that.
Okay, I'm not going to waive them, but I'm going to give you 1 year to pay.
Thank you, ma'am.
And I'm going to sentence you to 5 days in the Broward County Jail. Credit for time served.
Judge, good luck, sir.
Thank you, Your Honor.
So if we could call the case here, let me see. We could call Eric Shane Skoglund. You here on that case, sir? Okay, would you like to be seen or heard? Okay, you can step right up here to the lectern if you'd like to. How about on Mr. Skoglund?
No, Broward, Your Honor. Mr. Scogan refused to attend this morning.
Okay. This is on page
Page 5.
5.
Deputy,
Yes.
I can't recall, did Mr. Scope, was it a medical reset yesterday, or did he
You
refuse
refused yesterday as well.
Okay, that's what, Your Honor, in light of that, usually, and what I told Judge Halal is Judge Powell, when someone refuses, she'll usually give them a day, reconsider. After 2 days, Your Honor, I'm gonna ask that the court proceed.
Okay. Mr. Skoglund is charged with domestic battery by strangulation and resisting an officer without violence. We do have someone here, sir, if you wouldn't mind telling me your name.
Sentinel.
Okay, and what would you like to tell me this morning?
I'd like to say a couple things. First is, I'm in fear of my life from him. He's broken bones in my body. When he strangled me, I lost consciousness. He kept on kicking me to see if I was alive. I've tried helping him. He was homeless when I met him. He has, in the past couple of years, has several things, whether it be with crack cocaine, where it becomes violent, battery, several other cases of battery. I was trying to help him with all that. Again, I want to state, I'm in the fear of my life. He was put on that kind of house arrest ankle thing. He cut it off. He beat me up that day. I've never pursued. The state attorney, Peter Lamar, I think is the name, contacted me and told me that he hopes this time I pursue. I don't like coming here. I don't wish this on anybody, but he's a danger to everybody around him. And
Okay,
he's also left the state during the other case. He went to Alabama to his mother's, and there was a thing, extradition from the Broward County courts to get him back here. And he got arrested while he was up there for all kinds of stuff like this also.
okay,
I am truly in fear of my life. If he gets out on a bond, he's going to kill me. Once he knows I've been here, he will kill me.
okay.
Or if I can
Let me
just
hear from
ask-
the state for a
Well,
minute.
If okay, is it okay if I could just ask Mr. Simonelli a couple questions?
Sure,
Just-
sure.
And I apologize, was he placed under oath?
He was not. You want to raise your right hand, sir? Do you swear or affirm to tell me the truth?
Yes, I do.
And if you would state your full name?
Mitchell Thomas Simonelli.
Okay, yes, sir.
Thank you, Your Honor. Mr. Simonelli, I'm just going to ask you a few questions, if you could just provide a yes or no answer. Your Honor, Mr. Simonelli, Mr. Skoglund was arrested for a battery in 2018. Are you aware of that? Were you the listed victim?
He's
you
beat me
recall
up
it
so many
was-
times, I don't remember.
I'm sorry, it was this year, in May of this year. I apologize. Do you recall that in May of this year?
Yes.
Okay. And a case filer from the state attorney's office called you and spoke to you about whether you wanted to prosecute. Do you remember that?
They left message, my mom had died that month I was in New York.
And do you recall advising the state that you didn't want to prosecute, but it was because you had health issues? Do you recall that?
Can you repeat? I'm sorry.
Do you recall advising an assistant state attorney that you did not want to prosecute Mr. Skoglund for the battery because you had health issues?
Yes.
And- okay, it wasn't because he didn't commit the battery against you?
Correct.
Okay. Your Honor, I have nothing further.
Okay, you have a recommendation on bond?
I do, Your Honor. First, I want to bring to the court's attention that from what I can tell, Mr. Skoglund, just want to get make sure that it's still active. It is. Mr. Skoglund is out on bond right now for felony battery due to priors and criminal mischief before Judge Merrigan. In addition.
You have that case number?
I do, Your Honor. It is, whenever you're ready.
Yes.
189336 CF10A. He additionally, 2006 burglary of a dwelling. He was sentenced to 9 years in state prison as a habitual offender. 2006 felony batteries due to priors and felony theft, 5-year state prison. 07 felony criminal mischief, 9 years state prison, habitual offender. 06 grand theft and grand theft auto. He received the same sentence to run concurrent. 06 burglary of a dwelling, grand theft. Again, he received the same sentence to run concurrent. 2000 battery. He's had multiple other priors, but those are the most recent and relevant priors.
Is
Your Honor.
Mr. Simonelli the victim of the case where he's on bond?
No, Your Honor. Your Honor, in light of his priors, the testimony from Mr. Simonelli, and just, Your Honor, frankly, the egregious nature of these allegations, Your Honor, noting specifically that it's alleged Mr. Skoglund used a cord to strangle the victim, and the strength of the evidence, and that it was captured on a Ring video surveillance camera.
I have that.
Sir, okay. Your Honor, I'm going to be requesting a $25,000 bond on count 1. I imagine the court was asking for the case number because it's the court's intent to revoke. I don't know what's going to happen with this case, so I would also ask, should he be eligible for bond, a release on this case at some point, that he be supervised by pretrial release with a GPS monitor level 1, and obviously no victim contact.
Okay. Yes, sir.
Your Honor, I've come down to the courts several times, including my roommate, trying to get a restraining order due to all these things, from fractured ribs to I can go on with my teeth broken out of my mouth. And every time I went down there, they said they had to serve him. The police would come to the house when he came there. By the time he got there, the police got there, he'd leave. He'd come back half an hour later and break all my windows and stuff. I'm asked for some kind of restraining order to keep him
Okay,
anywhere away from me.
so this is the wrong courtroom for a restraining order, but you can, the state attorneys can direct you where to go for restraining order. I'm here today to determine the bond on this case and also to consider whether or not I should revoke the bond on the case that he's currently on bond. Those are the two issues that are before me today. So let me just go one step at a time if you don't mind.
Your Honor, I can advise Mr. Sentinel, if he doesn't mind waiting for a few minutes, our victim advocate will be back and she can provide him information and assistance.
If you want to
in
be
seeking
patient, they have
a,
someone coming back you could speak to.
Thank you.
Okay, so with regard to the case that's here before me this morning, I do find probable cause based on the probable cause affidavit, and I am going to set bond on this case in the amount of $25,000. As a condition of that bond, if he were to be able to make that bond, he would be supervised by pretrial release, a GPS monitor level 2. Is that right? Level 2? Level 1?
well, I was requesting level 1.
Level 1 is the one where he can't.
Level 1's total home lockdown.
Yes, level 1, that's the, level 1. On case number 189336 CF10A, the court is going to revoke his bond based on the allegations in this case and order that he be held no bond on that case. I will sign an order to that effect. Do you need me to draft it, or can, you got it?
Yeah, no, of course.
Would you,
Yeah,
what,
sure.
would you draft it? Okay,
Absolutely.
okay. No victim contact. Okay, anybody else in the audience that needs to be heard or wants to be heard? Okay. And I'm just gonna go right in order that the ones I have them, if that's okay with everybody. I have the first, Marquita Sims.
No problem.
Good morning. Miss Sims, you're here this morning charged with criminal mischief over $1,000 and resisting an officer without violence. I do find probable cause as to those charges. I want to hear from either the public defender or the state with regard to bond.
Judge, I'm going to be asking the court to consider pretrial release for Ms. Sims. We did discuss the importance of her staying away from this, I guess actually ex-boyfriend. She does have another place to stay.
She does or does not?
She does, she
Okay.
does. She'd be staying at a friend's house in Sunrise. She's been a resident of South Florida for 12 years. She's been living on and off the same location for the same amount of time. Unfortunately, she is not working. She suffers from a disability that makes it impossible for her to work at this point. And so therefore, she has no financial means to post a bond.
Your Honor, I would just want to bring to the court's attention, Ms. Sims is currently out right now on bond in drug court before Judge Porth for possession of substituted cathinones.
What case number is that?
That would be,
Does she have a court date with Judge Porth?
she She has a status on the 28th.
I do find probable cause, as I said, and are there any priors besides the one that's pending?
One moment, Judge. See anything other than that? No, yeah, no, just that, Judge.
Okay. I'm gonna leave bond in the amount of $500 on this case.
The only other thing I request, Your Honor, is no victim.
And, no victim contact. So if you're able to post the $500 bond, you're not permitted to have any contact with the.
I no longer want contact with him anyways because he always beats me physically. I've already called 911 before this incident.
Okay, I don't want you to say anything
Day
else.
before?
I don't want you to say anything else about the case, because everything's
ma'am.
being recorded, okay?
Yes, ma'am.
Okay,
Yes, Your
so the bond on this case is $500.
Yes, Your Honor. I currently don't have any money at the moment to bond out. I was wondering if there's any other way I can do something to make up for the bond for this case in order to get out.
Ms. Sims, I'm gonna let your public defender, Ms. Rowley, know that you're in custody.
This case will go to Judge Porth as well.
In that case, that other case is in Judge Porth, and I'll have her take a look at the bond situation for
So
you.
it's already,
okay?
she's got a court date of the 28th, so maybe we
Right.
can just make
I
that
see
note,
that.
okay? All right, thank you.
Thank you.
Is there anybody else? Okay, the next one I have is Keela Smith.
She's here present, Judge of Maine.
Maine? Okay. I have here before me a probable cause affidavit for the charge of obstructing a criminal investigation by giving false information to a police officer, as well as a felony capias for a violation of probation with Judge Bailey. I do find probable cause as to the new charge of obstructing, and there is a no bond hold on the case with Judge Bailey. There is a status scheduled for the 23rd, which is tomorrow. Okay, so there's a $100 bond on the new case. Okay?
Thank you, Judge.
Is it detective? Is it detective? Or
Next case.
Tyler? Is that it? Okay.
Yes.
No problem, John.
Okay. North Broward. Okay, this case, is this Tracy Tyler?
Yes.
Okay. And your name, sir?
Detective Steve Castor from Hollywood PD.
Okay. We're here this morning. There's a capias for a felony. The charge on that capias is an arrest warrant from Judge Usan for possession of cocaine, as well as an arrest warrant signed by Judge Usan on a sale of cocaine. There's looks like the warrant was served. So there are three separate charges: capias, a sell cocaine charge, and a warrant for violation of pretrial release. It looks like there's a status with Judge Tobin Singer on the 23rd on the case where there's a violation of pretrial release. And there is a, do I need to set a bond on the capias felony?
Those were set in no bond, Your Honor.
It does show no bond. Okay, I do find probable cause. I have seen both the capias and the arrest warrant in this case, and the arrest warrant indicates that Judge Usan has ordered previously that no bond change be made until and unless she sees Judge Usan. So bond on that is $25,000 on that one, right?
So, and Your Honor, I was going to be asking that the court keep the bond and the special release conditions in place. Additionally, I would note the pending case in front of Judge Tobin Singer, and I have a concern for her future appearance. She failed to appear in court And noting the pretrial revocation warrant signed by Judge Tobin Singer, she never even showed up to pretrial upon her release from custody.
Right, so the court's gonna keep it as it is with no bond on those and 25,000 on the other one. And, there's a hearing scheduled, as I said, tomorrow with Judge Tobin Singer. You'll see Judge Tobin Singer tomorrow.
For the record, is the court keeping the special release conditions in place?
Yes, just the way it is. It's already included in the order. All conditions of the warrant stay in effect? Okay. Okay. Thank you. Next, I have Naomi Hope. Paul Ryan, thank you. Ms. Hope, you're here this morning with an ad charge of petty theft. I do find probable cause. There is an ad charge, capious, for a $100 ad charge.
Ms. Hope is being held on a $1,000 bond for a grand theft firearm that was
I see
down
that.
file from home invasion, so I'm just requesting that this $100 bond be kept in place.
Okay. I do find probable cause, and the bond on the ad charge is $100.
Judge,
Okay?
Ms. Hope has indicated to me she's not gonna be able to make that $1,000 bond.
Okay. That's been
I know it's
previously
not
said.
properly before the court this
Right.
morning, but she did ask me if I could ask the court to consider reducing that bond.
Judge Shalal
Okay.
set that bond yesterday.
Ms. Hope, the bond on the other charge was already set by a different judge. So today, you're just in front of me on the ad charge petty theft. So that other bond is not before me here this morning, but you are represented by the Public Defender's Office. They can address your total bond, which is 1,000 on count one and 100 on this count, with the judge that you're gonna see, okay?
Okay.
Okay.
And I'll make that
Thank
call
you.
for you.
Okay.
Okay, thank you.
Okay,
You're
next,
welcome.
next we have Glenn Randolph Garraway.
He's here, present, Judge, at Maine.
Okay, we're here on that case for an out-of-state hold from Texas. And the paperwork indicates that he must go to Texas to post any bond. I do find that probable cause that there is in fact a warrant holding him from Texas.
Thank you, Judge.
Okay. Next, we have Victor Alexander Jimenez.
He's approaching, Judge, here at Maine.
Okay, Mr. Jimenez is here charged with robbery, no firearm or weapon, aggravated assault with a deadly weapon, domestic violence, and neglect of a child without great bodily harm. I do find probable cause as to those charges. I'll hear from either side or both sides regarding bond.
Your Honor, the state is going to be requesting bond in the following amounts. $10,000 on count one, $10,000 on count two, $2,500 on count three. No victim contact with any of the listed victims, which includes the minor child. Your Honor, Mr. Jimenez's history includes 2016 burglary of a conveyance and theft, 08 strong arm robbery. There was an arrest for battery in 09, that was dropped. He was convicted for battery in 07. He received a withhold on a battery with a theft in 06, resisting without violence 06.
Okay, I'll hear from you.
Judge, first in speaking with Mr. Jimenez, I did advise him today is just simply a day to set his pretrial release conditions. It's not his trial date. He'll have that opportunity in the future, but he very much is looking forward to having his day in court and disputing these allegations. When I advised him what he was charged with, it came as a shock to him as far as the robbery offense. My understanding, Mr. Jimenez was simply asking his wife for gas money, but having said that, I told him that's for a different day. Judge, Mr. Jimenez is not gonna be able to afford the $22,500 bond, which the state is requesting. We were gonna be asking the court to consider a $5,000 bond on count one, $5,000 bond on count two, and we're okay with the bond recommendation from the state on count three. My understanding is he's been living in our community his whole entire life. He's 31 years old. He's a tow truck driver. He's been doing that for the past 11 years. Right now, they are living apart from each other. I did advise him that the court's going to be imposing a no contact order. He will be abiding by that no contact order. He will be living with his mother, who resides in Davie. My understanding is he's going to be relying on his mother to help post his monetary bond, and he believes using the services of bondsman, the most that she could probably come up with is if the court were able to impose a $5,000 on one and $5,000 on two, and that's why we're requesting that amount. And my understanding, this is the first time he has no prior convictions for any domestic related issues, Judge.
Okay. I do, as I said, I do find probable cause as to the charges. As to count one, I'm gonna set bond in the amount of $5,000. As to count two, I'm gonna set bond in the amount of $10,000. As to count three, I'm gonna set bond in the amount of $2,500. As a special condition of the bond, he is not to have any victim contact whatsoever. That includes the minor child until further order of this court or another court, so no contact.
Thank you, Judge.
Next, we have Brandon Wayne Waring.
North Broward.
North Broward.
Good morning, Your Honor.
Good morning, Mr. Waring. You're here this morning charged with domestic battery by strangulation in a dating relationship, and aggravated battery caused bodily harm. I do find probable cause as to those two charges. I'll hear from the state first regarding bond.
Your Honor, Mr. Waring has a pending theft, no history other than that. That being said, I'm going to be requesting a $25,000 bond per count, pretrial release of the GPS monitor, no victim contact. Frankly, upon reviewing this probable cause affidavit, I think Mr. Waring could have been charged with a much more serious charge. Frankly, this reads like attempted murder to me. The allegations that he strangled the victim with the cord, and while strangling with the cord, held the victim's head underwater in a hotel bathtub. Noting that the victim had noticeable strangulation marks consistent with the cord being wrapped around his neck.
Hear from you, Mr. Reedy.
Yes, Judge. Mr. Waring is very much looking forward to his day in court on this. There's a lot more going on here than is contained in the four corners of this probable cause affidavit. I'm going to ask the court to consider a much lower bond than that. I was just on the phone with Mr. Waring's mother. She indicated to me that it's going to be difficult for her financially to post a bond for him. She would like to see him placed on pretrial release. My understanding is he has no prior criminal record whatsoever. His mother also indicated to me that there is quite a backstory as far as this tumultuous relationship is concerned, and that the alleged victim in this case is not always the victim.
Objecting to that, Your Honor, there's no basis for that.
Well, there is, because I was just told that. It's hearsay, like this police report. He has places he can stay, Judge. He has friends that he can stay with, so he will not need to have any contact with the alleged victim in the case. Unfortunately, they do own a cleaning company together. I explained to Mr. Waring that if he is able to bond out, they cannot be working together. He cannot have any contact whatsoever with this gentleman, and must stay away from him at all times, and cannot have any third party communicate with him or anything like that. And he's willing to abide by those conditions. So in light of the fact that the monetary situation is not all that great, as far as Mr. Waring is concerned. And he does have strong ties to the community with his mother, who,
Does his mother live here?
yeah, she lives in, what city does your mom live in?
Okay.
Boca. So he does have ties to the community. I'd again ask the court to place him on pretrial release.
And Your Honor, I would just note, and I know the court's already aware of this, but I'm just noting for record purposes, the probable cause affidavit is sworn to by a law enforcement officer. The defendant's mother, who has a clear bias, did not make any type of sworn statement, regardless of whether it's hearsay or not.
I don't know that his mother has a bias at all. And the only thing this officer saw was a mark on the victim's neck. He didn't see what happened.
Okay, well, based on the allegations in the probable cause affidavit, I do find that there is probable cause to set a bond on domestic battery by strangulation and aggravated battery causing bodily harm or disability. On count one, I'm going to set bond in the amount of $10,000. On count two, I'm going to set bond in the amount of $10,000. And on, if he is able to post the bond, he will be released to pretrial release on a GPS monitor. That'd be level 1, and he is not to have any contact whatsoever with the victim in this case.
Thank you, Judge.
Okay.
I'll call your mom back, Brandon. Okay?
Thank you. Thank you, Your Honor.
Next, I have Jagdish Nanda. Still on medical loan?
As soon as she's done, come back in here, please.
How about Christopher Roberts?
He's here, President Main Judge, approaching. Come on up, sir.
Mr. Roberts is here present on a capias for a 2017 case. It looks like charged with driving on a suspended license. The capias amount attached is $250. I do find probable cause based on the capias that exists.
Nothing to add from the defense, Judge.
Okay, let me just see here. State have any position on this?
No, Your Honor, if he's not
Looking at his driving record, it
It's-
looks like he might be eligible for the driver's initiative if he gets out.
And I'm guessing, based on Mr. Romero's representation, he's looking to post his bond, so.
Okay. Bond's $250, okay?
Thank you, Judge.
Next, we have Keith Gerard Presley.
Northbriar.
Good morning, y'all.
Good morning. Mr. Presley, you're here this morning charged with battery causing bodily harm. I do find probable cause for that charge. I'll hear from both sides with regard to the bond.
Judge, I'm going to ask the court for pretrial release. I know that Mr. Presley's had some contact with the criminal justice system in the past, but he is a lifelong resident of South Florida, and he's been staying in the same location for the last 20 years. This case appears to be one punch. My understanding is that the alleged victim in the case was invading Mr. Presley's personal space. Mr. Presley warned him to back off, and when he didn't, he was struck one time. So it's not like a bunch of fists were thrown or a bunch of punches were thrown. It was one punch.
State.
Mr. Presley's history includes 2016 grand theft auto. He was qualified as a habitual offender in that case. 07 grand theft, 5-year state prison. 07 sale or delivery of cocaine within 1,000 feet of a school, 5-year state prison as a habitual offender, trespass 02, delivery of cocaine 02, battery 02. He's had other priors. Those are the most relevant recent.
It seems that other than the battery in 2002, most of Mr. Pressy's crimes are non-violent.
Also noting he's used multiple aliases in the past, looking at the booking sheet.
Okay, based on the allegation in the probable cause affidavit, I do find probable cause. Bond is set in the amount of $1,000.
Just request that
No contact whatsoever with the victim in this case if you're released on bond. You understand?
Yes, ma'am.
Okay. I have Lorenzo Devon Tyrese Kinder.
Judge, he's here, President Maine.
This looks like this is an ad charge for operating without a valid driver's license. Is that right?
Yes, ma'am. I'm just checking.
I see it as an ad charge.
Looks like the only thing holding Mr. Kinder at this time. Showing he entered the diversion program previously. I don't know what what effect this capias will have.
Pardon me? He was in custody when the capias was issued. Okay.
That's what I was gonna ask the court. My understanding, Judge, he's been in custody for over 30 days, about a month and a week.
Is there something else holding him?
No, if it was issued while he was in custody, if it was issued while he was in custody, he's entitled to an ROR.
Okay. So it was originally issued as a capias for $1,000. I'm going to release him on his own recognizance on that charge. But you do need to understand, Mr. Kinder, that you're going to have to go to court on the case.
All right.
You understand?
Yes.
Okay.
Thank you, Judge.
Okay. We have Shane McGuire.
He's here, President Maine, Judge.
Okay, Ms. McGuire's here, looks like transferred from St. Johns County. He's here on a violation of probation on 2 cases and a traffic capias. The violation of probation cases are for Judge Pohl. The warrant was signed by Judge Pohl in December 2015, and those are no bond holds. Does look like he has a status with Judge Pohl tomorrow. Okay, so I do find probable cause. You'll see Judge Pohl tomorrow on these cases. Okay? I have Jafith Jean-Francois.
Conti, Your Honor. Yes, Your Honor.
Conti. Okay, I have a charge, looks like count 23 and count 24, so these must be ad charges as well.
Yes, ma'am.
Charged with burglary of an unoccupied dwelling and grand theft. I do find probable cause as to those charges. I'll hear from the state with regard to bond
Your Honor,
first.
Mr. Jean-Francois has no bond holds. The bond on his last bird dwelling that he was charged with, that he's being held on, was set at $5,000. I'll ask that this bond be set at $5,000, and that the court also issue a release condition: no victim contact, no return.
Okay. Does the defense wish to be heard on this case, on Jean-Francois? Is that
No, Your Honor. Mr. Francois has numerous no bond holds.
Okay. On
He
this
has an
case,
immigration hold.
okay.
So I just asked for a reasonable bond on count 23.
On count 23, the court's going to set bond in the amount of $5,000. Count 24, bond is set in the amount of $1,000. I'm also going to order that if he were to be released, that he have no victim contact and no return to the location where this incident occurred. You understand, Mr. Jean-Francois?
Yes, Your Honor.
Okay.
I got a question, Your Honor.
Wait, okay, I don't want you to say anything about your case. I would rather you talk to your attorney privately about that, but you can ask me any question that doesn't,
I don't have.
go ahead,
My bad.
go ahead.
I don't have a public defender signed to the cases.
You do not?
No, the new cases that just been added, 23 and 24.
Oh, okay, I think that probably whoever your public defender is who's assisting you on your other matters will help you with this as well.
All right, thank you, Your Honor. Have a nice day.
Okay, you too. Next case is Breon Christopher Atwell.
Also in Conte.
Good morning, Mr. Atwell.
Good morning.
You're here today for an additional charge that's being added. It's a charge of possession with intent to sell, manufacture, or deliver fentanyl. And I do have, I have reviewed the paperwork of the original counts that were counts 1 through 7, where bond was set and other conditions of the bond were. I'll hear, this case has a $3,500 convenience bond. Do you want to be heard on that?
Not on the ad charge, Your Honor. I think there's been a clerical error on one of the other counts, and since the case is before the court, I believe Your Honor can address it.
Okay.
If you want to just deal with the ad charge first, and then...
On the ad charge, I do find probable cause, and the bond on that is $3,500. Okay? What's the issue
I
with
would direct the court's attention to the capias that was created by the clerk's office upon the change of charges in the ad charge.
Okay, that's the one I have that I'm looking at.
Yes, as you see on count 1, trafficking fentanyl, for some reason the clerk's office put a $7,500 bond on that.
Okay?
The standard bond for trafficking fentanyl in that amount is $75,000. Additionally, Your Honor, what I provided the court is the register of actions from this case, defense motion, and defense motion for reduction in bond. Your Honor, first, I would refer the court's attention.
Problem is that Mr. Atwell has an attorney.
Here's what, and here's the other confusion about that. Let me just see. Okay, if we could put it on recall then, and I'll reach out to Mr. Lewis.
Okay, what we can do is reach out to Mr. Lewis's office and see if he's in the building. If not, I could call him and he could maybe appear by phone. But we're gonna put your case on recall, Mr. Atwell, so we can talk to your attorney, okay?
Okay.
All right. No, I'm just gonna keep it aside for a minute and see if we can reach out to, we might be able to do it this morning. We have Archie Van McNair. Where's he, in Maine?
Yes, Judge, he's approaching.
Okay. All right, looks like Mr. McNair's here on a grand theft and illegal use of a credit card. Attached to that paperwork is a case that he was state sentenced on, looks like yesterday, by Judge Coleman, and he was remanded to custody. Is that right?
Correct, Judge. He was remanded to start serving his 21-month sentence.
Right, okay, so as to the other charges, the grand theft and the illegal use of a credit card, there is a warrant that has already been signed to arrest Mr. McNair for those charges, and the bond set on that warrant signed, I believe it's by Judge Bailey, indicates no bond on each of those 2 counts.
And Your Honor, he is...
Judge, I believe it's no bond for purposes of going before a magistrate. He's still entitled to a bond, but as you said, he's not going anywhere. He's going to serve his 20-month sentence.
And it looks like he has a status with Judge Bailey tomorrow.
And state's requesting a $1,000 bond on each count.
Okay, so I'm gonna set a bond on the grand theft of $1,000 and set a bond on the illegal use of a credit card in the amount of $1,000 and find probable cause as to those 2 charges. And it looks like I said, he's gonna see Judge Bailey tomorrow.
Is there a third grand theft?
That's what he was state sentenced on.
No, the third count appearing on my probable cause determination form is a state sentence case, which the state sentence is attached to the documents, so, okay? Okay, next I have Matthew John Nick.
He's approaching, Judge, he's here, man.
Okay, is it Nick?
Yes.
Is here charged with driving while suspended license, third or subsequent offense, and a traffic infraction for expired registration. I do find probable cause.
Judge, in speaking, Mr. Nick, first, as far as what the offense is, as far as the felony driving, my understanding from what he advised, he believes he only has one prior driving while license suspended. But having said that, Judge,
I'm looking at a driving record that shows one in 2008 and one in 2016.
2016 is the only one I didn't know 2008.
And then it looks like there's one in 2006 that might not qualify as a underlying offense. I can't tell specifically, but it looks like it might not. So, based on that, the allegations in the probable cause affidavit, I do find probable cause. I'll hear from you with regard to bond.
Judge, Mr. Nick advised me he would want me to ask the court to consider releasing him on pretrial release. My understanding, he's a registered voter in our community. He's been living here since he was 9 years old. He has health issues. He doesn't work. He is on disability. He lives locally here in Fort Lauderdale. He will be coming back to court. So he's asking to be released under supervision of standard pretrial.
State.
One moment, Judge. I have no objection to pretrial, Judge.
Oh, I didn't do it. Thank you. You said, I'm sorry?
I have no objection.
Okay. All right, I'm going to release him on his own recognizance to pretrial release. He's going to be required to call in 2 times per week. You're also going to be required to report to pretrial upon your release from custody. You understand, Mr. Nick?
Yes, ma'am.
Okay.
I know.
Thank you, Judge.
What's grand jury time? Oh, and Your Honor, just to let you know, Mr. Lewis is on his way.
Okay. Okay, I have Quincy Latius.
Mr. Latius, come on up.
Judge, I left a message for Mr. Johnny Weeks's office earlier this morning, and they said they were going to text him to get him to come over here as soon as possible.
Oh, Mr. Weeks represents him?
Yes, ma'am.
Okay, so we're going to put this on recall for a minute, and hope that Mr. Weeks, your attorney, will come over, okay? Okay, on Todell Jamel McFarland.
Judge, I've been advised he's in regular court, 5750.
Wait, did we have him yesterday? I could have.
It says he was,
Yeah, and Your Honor.
it says, please schedule for first appearance, room 4155, Judge Powell, thank you.
Your Honor, I'm going to ask that the court make a PC determination pursuant to rules of procedure. He doesn't need to be present. The reason being, he's in court right now for this very case that he's on, the probation case. And as you don't have the docket in front of you, but pursuant to administrative order on a very literal reading, the clerk's already scheduled him for a status tomorrow in his division. If we reset it when we're here tomorrow, we're going to be told he's in court again. And it just goes on a loop over and over.
So if he's in court, why can't we get this paperwork to where he is in court?
I don't know. Well, I don't think they even need this paperwork. He's there on the VOP. They'll have the violation of probation.
Okay, well, usually I get the magistrates, when they
Oh,
bring him
really?
over, I get the magistrates' paperwork in my courtroom, but I'll find probable cause as to the violation of probation. It does look like he's scheduled for tomorrow on this paperwork, so
Yeah.
we'll see what happens. He takes care of it today.
Nancy, you have the next one? Oh, I saw you standing.
Thank you. Okay, how about Luigi Jerome Johnson?
He's here, President May.
Mr. Johnson is present here today. He's charged with grand theft auto. I do find probable cause for that offense.
Judge, nothing to add at this time. I'm going to be contacting his friends and family to post his monetary bond.
Okay, state okay with the bond?
Yes, ma'am.
All right, the bond is $1,000. Okay?
Thank you, Judge.
Next, we have Jesse Hall.
He's approaching, Judge May.
Dade wants him back when we're done. Dade wants him back when we're done.
It looks like Jesse Hall, you're here with one count of grand theft and one count of fraudulent uttering of a false instrument. I do find probable cause there is a capias for those charges. And the bond set on the capias was $1,000 on each count.
Judge, I spoke with Mr. Hall, I believe, afterwards, there's a hold going to be placed on him from Dade, or there might be a hold.
I think
So
they
nothing
said
to add
he's already got to go to Dade County when he's finished here.
The hold's already been placed on him.
So nothing to add from the defense, Judge.
Okay, so
Nothing
bond
from
on these two is $1,000 each for a total of $2,000. Matthew Everett.
Bonded?
Okay, counterfeit, false making a credit card, grand theft auto, and possession of a similitude driver's license. I do find probable cause. Looks like bond was previously set in the amount of $1,000 on each count. Next, we have Antrell Fiena.
He's here, President Judge May.
Looks like there is a out-of-state hold and also a felony violation of probation. Each of those are no bond. I do find probable cause there is a violation of probation warrant. There's a hearing scheduled for tomorrow with Judge Duffy. And then we have Javon Bernard Springer. Medical reset again. Okay, that just gives us then the two cases where we're waiting for the attorneys.
I just talked to Mr. Weeks' office again. They're gonna call him again.
And Your Honor, I'm on with his office also, because I suspect once I speak to John, he's probably not gonna want to come down here. We'll have an agreement based on what's going on
Okay.
here.
All right.
Did you get that? Judge, I believe this gentleman, William, Mr. Weeks, is the last person here at Maine.
Yes, we're waiting
So
just to
I'll
hear
see you
back.
this afternoon.
Okay, see you then. Thank you.
Thank you, Judge.
And Jim told me he would be here in a few minutes. He was
Okay.
nearby.
Do we stay on the record or
I think we can.
Take
I
a
think
break?
Yeah, we don't have to stay on.
Okay. We're just gonna take a break for everyone who's there. We're gonna be off the record just for a minute while we try to get in touch with some of the other attorneys, the two attorneys. System off. we are going to call the case of Quincy Latius. Is that right?
Yes, ma'am.
Okay, and that is North Broward, I think? Oh, Main Jail, sorry. Okay. So, Mr. Latius, you're here this morning. You are represented by Mr. Weeks.
Yes, ma'am.
And Mr. Weeks' office was just contacted by the state attorney's office, Mr.
Yes, Your Honor. Yeah, I just got the phone, Mr. Weeks, Your Honor. As you can see, Mr. Latius was brought here because there was a grand jury indictment. The charges that the grand jury indicted him on are identical to 3 of the charges he came before Judge Powell on at his first appearance. I provided the court with the original findings.
Right.
The only difference is that the grand jury did not indict him for kidnapping. What I was going to be requesting, and Mr. Weeks understands, is that the court adopt Judge Powell's previous findings
Okay.
for the same offenses and reissue the no bond on the murder first degree, attempted murder first degree, and set the $25,000 bond on possession of firearm by convicted felon back in place. And obviously, Mr. Weeks is familiar with what's going on. He told me, and he said it's okay for me to represent to the court, and Mr. Ladies can hear. He's going to file, he will look into filing the appropriate motions, but he is aware of the situation.
Okay, so Mr. Quincy Latius, I do find probable cause as the grand jury has issued an indictment as to count 1, a premeditated murder. The court is going to adopt the finding previously by Judge Powell. Looks like that was done on the 2nd day of October, and that case is no bond, is that right?
Yes, ma'am.
That charge is no bond. And then count 2, the attempted felony murder, also a no bond, is that right?
Yes, ma'am.
And that's consistent with the paperwork from Judge Powell on October the 2nd that your attorney was aware of and has agreed upon. And as to count 4, possession of a weapon by a convicted felon, the court's going to adopt Judge Powell's previous findings and set bond in that case, in that charge, in the amount of $25,000. So nothing has changed in terms of your status except for the fact that the grand jury did not indict you on the kidnapping charge. So I'm going to tell you that you should speak to Mr. Weeks, and he'll advise you on how you're going to proceed from here. Okay?
All right.
Okay.
No problem.
All right. All right, we'll be off the record for a minute until we get Mr. Lewis. Arrived. Good morning, Mr. Lewis. We are on Brianni Christopher Atwell, and I think he was at Conti? Mr. Atwell,
Let me make sure, I could be wrong.
North Broward, or?
Oh, okay. He's a Conti.
Oh, he's in Conti? Okay, Mr. Atwell, good morning. Your attorney, Mr. Lewis, is here. He has arrived on your case. We're here this morning, Mr. Lewis, on a count 8, possession with intent to sell or manufacture fentanyl. It was an additional charge. I did find probable cause as to that, and bond is set in the amount of $3,500 on that particular count. Mr.
Your Honor, I'm also, because this case number is before the court this morning, I'm asking if the court would be inclined to correct what I believe amounts to a clerical error. As you can see on the change of charge, on the KPS that was issued by the clerk, on the change of charge on count 1, which was one type of trafficking to another type of trafficking, the clerk for some reason said a $7,500 bond. The convenience bond for trafficking fentanyl in the amount that was filed is $75,000. The same as the trafficking in MDMA that he was originally arrested on. Additionally, you can see Mr. Lewis filed a motion to have the bond reduced from the $75,000. As you can see, I didn't see an order uploaded, but I did print the register of actions where you can see that Judge McCarthy denied the motion, clearly indicating her intent that the bond on the trafficking amount stay at $75,000, Your Honor. This actually, and Your Honor, I believe this motion was heard after the information was actually filed.
Okay, is there an information that has been filed?
Yes, that's why we're here.
Okay, so the problem is that the order signed by Judge Powell doesn't match with the capias in terms of.
No, I'm not talking about the order that I printed out the order that Judge Powell, just to show that it was originally set at $75,000.
Okay,
You can see it, did I print out the register of actions?
yes,
Okay, as you can see, Your Honor, Judge McCarthy heard a motion to reduce bond and denied it. And that's why I also printed out Mr. Lewis's motion. As he puts in the motion, the bond on the trafficking was $75,000 at that time, clearly showing Judge McCarthy's intent that the bond stay at $75,000. What we're talking about is a lateral change. It's one type of trafficking for another. It would be one thing if it was a reduction from trafficking to possession with intent.
so Mr. Lewis, your motion to reduce or release Mr. Atwell on bond was actually heard by Judge McCarthy?
It was, but again, this came in as an MDMA count. That's where the $75,000 came in originally.
Well, it's the trafficking in fentanyl.
It's trafficking in fentanyl now, but I'm not sure that has the amount changed? I mean, what has changed about the count?
It's the type of drug, but I can, as an officer of the court, I can tell you, the convenience bond for trafficking fentanyl, it's $75,000. I don't know why the clerk put $7,500. The reason I'm arguing this is, frankly, Your Honor, I don't think the clerk should be able to determine if someone's bond gets reduced. Well,
they don't have the authority to do that. Everyone would agree with that. The question is, if the capias that's in front of me, that has a trafficking in fentanyl as count number 1 in the amount of $7,500, is the same allegation as the trafficking that you've already litigated with Judge McCarthy.
It was a change of charge from trafficking MDMA to trafficking fentanyl. When they tested it, they found fentanyl in the substance also, so they charged it as trafficking fentanyl. But it stems from the same charge.
So, Mr. Lewis, was your motion heard after the information was filed?
Sure. Your Honor, I believe if you look at the Register of Actions, the information was filed on 10/11. The motion was heard, I believe, on the 15th.
Okay. So you were basically arguing the motion to reduce bond on the information as it was filed, which is, according to the state, consistent with the charges that were originally filed. Do you agree that the bond is in error on this capias?
Yes, Judge.
Okay.
If that's what the standard bond on trafficking in fentanyl is.
So it looks like it might have been a clerical error from $75,000 to $7,500. So let me just get it correct. for the record, count one, trafficking in fentanyl, both sides agree that the bond should be $75,000. Is that right?
Yes, Your Honor, that's what the state would be requesting. And
No, I'm asking if that's what was the, before Judge McCarthy.
yes, yes.
That's what the
Okay.
judge ordered.
And then count two, possession of fentanyl, is the one that is in front of me today.
That's the ad charge. That
But
wasn't
it's
addressed in
listed as,
Mr.
it's listed as 8 on my paperwork.
It's listed as 8, Your Honor, because what happens is, the KPS reflects the charge in the information. The number 8 reflects, that's the 8th charge that they
Okay,
booked him on.
so the
to jail.
possession of fentanyl that he's in front of me today would be count 2 of the information, which has a $3,500 bond, is that right?
That is correct.
And then count 4 is possession of heroin, which is a $1,000 bond, is that right?
Yes, Judge.
All right, so the court does find probable cause as to the possession with intent to manufacture, deliver fentanyl, and bond is set at $3,500 on that. I will do an order correcting the clerk's system to reflect the bond that both sides understand. So the bond on count 1 is $75,000, the bond on count 2 is $3,500, and the bond on count 3 is $1,000. Actually, it's listed as count 4, just to be clear.
And if it's acceptable to the court, I'll prepare an order, but can I just prepare the order as to the trafficking, since that's the only bond amount that the court is changing at this time?
I think it'd be better if the order says that the,
I just don't want to create any potential confusion, considering that you're leaving the other 2 counts in place already.
right, okay. So that's okay with me then, if you just do count 1, that the court is just correcting a clerical error, that the bond should reflect $75,000, not $7,500. Okay?
Yes, Your Honor.
Mr. Atwell, you understand? Your attorney's here.
Yeah, I see him.
Okay.
There.
So we're gonna do a short order where we're gonna correct the bond amount on, that has nothing. I don't think they'll do a corrected KPS, they'll just change the bond amount.
And Your Honor, the state's position, frankly, that's between the jail and the clerk. That's why I'm preparing the order for Your Honor.
Okay,
No matter what happens, it's reflected that Your Honor's ordered that be the bond set in that charge.
all right. So on this one here, I'm just gonna give you this paperwork which finds probable cause as to the charge that was in front of me today. Okay? Anybody else want to say anything on the record before we recess? Mr. Lewis? Okay. Mr. Lewis, are you all set?
Yes, ma'am. Thank
Okay, thank you for coming over.
Good to be seen, I guess.
1213 CF10A. This is the case Mr. was just talking about, where it was supposed to be set for 30 days.
Okay, so,
That is
Mr. Linder,
correct.
I'm just gonna sign the order by agreement. It is hereby ordered the defendant be released on his own recognizance on the above styled cause of action.
Yeah, and Your Honor, for the record, the state stipulates, I checked this morning, the state has not filed an information at this time, and it has been more than 33 days.
Okay, I signed that order then on that case number, and I guess that will conclude the morning's hearing, and we'll be in recess till 1 o'clock. Thank you.
Your Honor, can I just have one moment to finish this order?
Sure, I'm not gonna go anywhere.
Thank you.